I'm joined now by former Solicitor General of India, Mr. Ranjit Kumar. Viewers, this entire battle has become a national crusade right now. In the last half an hour, the way we are being supported last 1 hour by the people of India is incredible. It gives me great sense of reassurance today. But Mr. Ranjit Kumar, this is Arnav here. Good afternoon. This morning at 8:30, our network CEO was abducted. And I say abducted because he was abducted without papers. 4 hours later, his wife received some kind of a notification through a WhatsApp message. This happens one day before his anticipatory bail application is to be heard before the relevant court. The Maharashtra government was served a copy of the bail application, the police. The individual in question, the CEO of the Republic Media Network, has been through 100 odd hours of questioning. He has been summoned on more than 10 occasions. On each occasion he has complied. He has given documentation. His SIM card has been taken away. His phone and laptop have been taken away. He's been served multiple 41 and 91 notices. He has complied with everything. He does not pose any risk. And yet at a point of time when one of my media executives was whiplashed in custodial torture with a chakki belt by a member of the Mumbai police, when that matter is before the National Human Rights Commission, we now have the abduction of the CEO of the largest media news network in the country. Is there no rule of law or due process, Mr. Ranjit Kumar? Are we being incarcerated because we are complying with the rule of law?
Well, Arnav, I'll put it like this, that first of all, according to me, an arrest one day prior to the hearing of the 438 anticipatory bail application is only to make that application infructuous. Because once you are already in custody, then there is no question of anticipatory bail. So that's the first thing I'd like to say. Secondly, the law requires that anybody at the time of his arrest is required to be given a copy of the arrest warrant and the grounds on which the arrests are being made. So if that has not been complied with, if that is a complete violation of the law, that you have not complied with either the giving the arrest warrant or a copy of the grounds on which you are arresting. So that's the second aspect. The third aspect is that the rule of law itself is flouted when you know that an anticipatory bail application 438 is coming up tomorrow on Monday. Then why are you arresting somebody on Sunday morning unless you feel that he is a threat to the society and the threat to the nation, and that it is in public interest to arrest somebody who has gone and joined your Section 91 notices for more than 100 hours, as you have informed me. So I feel clearly that the law must be followed by all, and if the manner in which this has been done is not right, as you have just now informed me.
But Mr. Kumar, what are the larger issues which are now emerging? My view is that the Mumbai police and the Maharashtra government is trying to surpass the judiciary. This is the only inference which I can do, because the TRP case charge sheet was filed when the matter was pending before the High Court. I give you another example. Yeah. When right after we approached the Honorable Bombay High Court against the fake and fabricated investigation into the TRP case, a charge sheet was hurriedly filed in 24 hours on bizarre and unrelated dual LCN claims, a matter which is before the Telecom Regulatory Authority of India. So what is clear to me is that this is being done to push away judicial intervention. An action to push away judicial intervention, isn't that itself a wrongdoing?
Well, according to me, denying somebody access to the judiciary or allowing the judicial process to go on in the manner known to law and trying to preempt a judicial process by doing something by which the judicial process can be thwarted or made nugatory or infructuous, that is not the correct way for any institution to move forward, let alone a state government.
No, absolutely that is. Now I give you one more example. When application was served in the Maharashtra government in the abatement case, they raced to file a malicious charge sheet. I'll give you an example. When we filed an interim application on the breach of the observations of the Supreme Court, and when we filed the IA saying that the Supreme Court has said that prima facie there is no 306 case against us, then Anil Deshmukh, the Home Minister, within 6 hours said, I will file a charge sheet. Now that was itself a contravention of the process, because Anil Deshmukh is not the investigating officer, he is prejudging the case. And within hours they rushed to file a charge sheet. So what is emerging very clearly is that the intent is to blindside our honorable courts, to block the scrutiny of the courts.
Yeah, so
and where this becomes a larger case is because we as citizens, law-abiding citizens, can only seek the protection of the courts.
Yeah, I quite agree with you. I would only put it like this, that in terms of the Supreme Court order, the requirement by the judgment of the two-judge bench was that the matter will now be heard by the High Court once again on your writ petition, and having expressed a prima facie view, the High Court will hear and decide whether even a case is made out or not. So if the High Court was yet to decide pursuant to Supreme Court judgment as to whether a case is even at all made out against you, then the filing of the charge sheet, as I said again earlier, that it is to preempt that hearing. You see that it appears to be that for some reason or the other,
but this is
they want to preempt the judicial process by taking action which they ought not to.
But would this aspect not be obvious before the Honorable High Court?
Yeah,
would the High Court not see it?
According to me,
would it not be seen with abundant clarity by the High Court about what they are doing?
Yeah, High Court should take a very serious note of this issue and take a serious view of the matter as to why the government is roughshodding, if I may use that expression, roughshodding the entire judicial process by moving in so that the judicial process doesn't take its course and trying to preempt what is to happen in court. That is how I'd like
Mr. Ranjit Kumar, this is a witch hunt at another level. At another level. Absolutely another level. This Malafide action, the witch hunt, attempts to surpass the judiciary, aren't they matters of grave concern? I mean, beyond my case, can I ask you, final question to you, beyond my case, this can happen to any citizen, this can happen to any channel, this can happen to any newspaper, this can happen to any news media house. And unless the courts intervene and with great clarity penalize those who are doing this, we will turn into a banana republic.
Well, therefore, that is why I said in the show which you telecast for me yesterday on Legal, that today the people are not willing to hear something against themselves. If I have a view and I express that view, and that view is not palatable to you, and you have a different or a contrary view, you do not want to accept that contrary view given or uttered by me. And that is a very dangerous thing. And as you say, put it, if the government itself were trying to understand that anything said against us will be treated as an umbrage to us and stifle my right to free speech, subject to the restrictions placed under section Article 19(1)(a), read with Article 19(2), if those restrictions, as contained in 19(2), are not violated, then you should not in any manner stifle the voice merely because it is a dissent or a view which is contrary to your own view, or which is a view which is one's perception and the other person holds another perception. That's how I'll put it, Arnab.